Good morning, everybody. Welcome to what is the fifth public user engagement event run by HMCTS and the second one online. And I'm coming to you live from my son's bedroom. Hopefully we will be able to meet again in person next year, but a big welcome from all of us in HMCTS to this week's events. I should probably start with an introduction. I'm Daniel Fleury. I'm the Deputy Director of Crime in HMCTS. That means I look after all things in the Magistrates and the Crown Court. And one of the things I'm going to talk to you about today is about what we call Section 28 provision for victims and witnesses, and in particular, some of the recent changes to these provisions and how they are supporting witnesses and complainants to give evidence in what are occasionally traumatic and difficult proceedings. I'm going to start off by giving a very basic introduction to Section 28 and the use of special measures, and the presentation itself will be quite a basic introduction, which I hope the layperson can understand. And as you will know, there will be plenty of time at the end of the presentation for questions and answers. So if we do need to get into some detail or want to get into some detail, we can certainly do so there. So just start off with a brief introduction to these special measures. Special measures are procedures, are support that can be provided in criminal courts that allow for witnesses, for complainants, to give the best evidence they can, really, to allow them to feel comfortable in that environment and to give the evidence they are best able to. And one of these special measures, well, there's a whole variety of special measures. Some are listed in the slide itself, such as the removal of wigs and gowns by judges and advocates, which is usually done when children are involved, or giving evidence via a live video link. One of these special measures is video recorded pre-trial cross-examination. Now, the reason why we call this Section 28 is because this arose from Section 28 of the 1999 Youth Justice and Criminal Evidence Act, and that set out ways in which we can record pre-trial cross-examination, and that would be played to juries in criminal trials in the Crown Court. But where is Section 28 available? Now, Section 28 has had a longish journey, really. As I said, the enabling legislation came about in the 1999 Act, but it wasn't really until 2013 when Section 28 was used in earnest, and it began with use amongst what we call vulnerable witnesses, and in particular, a vulnerable witness is someone who qualifies under the criteria set out in Section 16 of the 1999 Act. And as a rule of thumb, it means essentially someone under 18, a child, or someone with perhaps special needs or learning difficulties, and the eligibility is set out under that Section 16 criteria. In terms of the use, who can use it, how it can be used, the first port of call is via the police and the Crown Prosecution Service, and they will take the first step in identifying whether the witness is suitable for a Section 28 hearing and whether their evidence will be improved through using this special measure. But I just want to say that the final opt-in to actually use this measure is made by the witness, and then that will be considered, of course, by the judge. And what I do want to say is, this has been relatively successful in terms of the usage, and it's growing month on month. As I said, it began in a few Crown Courts in as early as 2013 and expanded over the last 5 years, but really accelerated somewhat surprisingly during the pandemic, and it completed its rollout to all Crown Courts around about November 2020. So we've been live for Section 28 for vulnerable witnesses for about a year now, and in the last 12 months, as the slide says, we've supported over 1,600 witnesses in this way across all of the Crown Courts. So the change that we've recently, well, it's partially introduced, but we've recently accelerated is to build on the elements of Section 28 for vulnerable witnesses, but also to extend it to intimidated witnesses. Now, And intimidated witnesses, the definition is described in that first bullet point of that slide. So section 17, subsection 4 of the 1999 Act, it identifies complainants in respect of a sexual offence or a modern slavery offence who are witnesses in proceedings relating to that offence and any other offences. So that's our definition, essentially, of an intimidated witness, and they are now eligible to use the provisions, the pre-recorded cross-examination evidence in support of giving evidence in that criminal trial. Now, the story of this, we initially embarked in a pilot for intimidated witnesses in our Leeds, Liverpool and Kingston upon Thames Crown Court. But the big change is that we've now extended this to 4 more Crown Courts, and we did so on the 30th of September 2021, and those are Wood Green, Isleworth, Harrow and Durham. So we now have a total of 7 Crown Courts where this provision is available. Essentially, we're sort of still continuing to test it, still continuing to understand how this operates, still considering how it can be managed in the most effective way. And we're doing this with a view to, well, 2 things really. One, something called Section 62 of the Domestic Abuse Act 2021, an act that received assent this year. On the next month, 15th of December, the provisions of Section 62 will be brought into force, and that will mean complainants of domestic abuse offences will be included as Section 17(4) witnesses. So if there's a case in the Crown Court with a domestic abuse element, whatever that offence may be, the complainant in that case will be allowed or will be able to submit an application to use the pre-recorded cross-examination special measure. I should also add as well that we've now extended these provisions to 7 Crown Courts. The Ministry of Justice, our colleagues in the Ministry of Justice, have committed to undertaking an evaluation of Section 17(4) of the provisions for intimidated witnesses, and that will be used to inform decisions on any further rollout. So just a quick run through of the process overview. How does it actually work? How does it get from the witness or the complainant into the court? So the first step is for the to produce a pre-recorded cross-examination. The witness must have what we call a video recording, or a video recording interview, also known as an achieving best evidence interview. And that needs to be, as I said before, the police and CPS need to be of the opinion that the measure would likely to improve the quality of the evidence by the witness. And so, that is quite an extensive and novel process undertaken by the police. And, there is certainly, how can I describe it, a requirement, an element of consideration by the police to ensure that that interview is of sufficient quality to allow it to be submitted for consideration for Section 28. The next element, of course, the CPS, the Crown Prosecution Service, need to be trial ready. And again, that it's what we have found through Section 28 is that it brings the process significantly forward, in that by the time the video is produced and by the time it's submitted for consideration, the CPS need to have undertaken significant amount of work and to have responded to any defence queries before the recording itself takes place, and that includes a disclosure. So there is a lot of work that is sometimes done towards, or a little further towards, the commencement of the trial to move to the sort of start of the process, and certainly in advance of the Section 28 recording. So the Section 28 recording, as someone very wise once said to me, memory is a painting, not a photograph. And what Section 28 we think does allow is, because the complainant or the witness is able to give their evidence and to be cross-examined at a far earlier date, it's thought that it may improve recall, may improve memory. And this early recording of the witness is is done not only to aid memory recall, but to reduce the distress experienced by some witnesses when giving evidence to a full courtroom trial. And we have some testimony later on in the slide which sort of sets out how Section 28 is going to support that. But one of the first things it does do is allow for that for the witness or the complainant to get their evidence down at the earliest opportunity. At the recording itself, the witness will be in what we call the vulnerable and intimidated witness video link room. That is a room within the Crown Court, in the majority of cases in a Crown Court, and that is out a little different, well, quite a lot different from the familiar courtroom setup, and will be a sort of more informal environment, of course, with lots of screens and microphones. They will be there with any appointed intermediary, any interpreter, any sort of witness support, and critically, the witness will not see or come into contact with the defendant in any way. And as you can see, that's quite a contrast to what would have taken place in an open courtroom during a trial, during cross-examination. I mentioned the vulnerable and intimidated witness video link room being in the majority of Crown Courts. We're also undertaking a project at the moment to allow for these recordings to take place at remote hearing centres. So these are typically witness support centres such as ISFAs, Independent Sexual Violence Advice Centres, and Independent Domestic Violence Advice Centres. And suitable locations where there is sufficient support and sufficient technology to allow for remote hearings to take place, something that we certainly want to develop in conjunction with the judiciary over the months and years ahead. So just to say a bit more on the process, make a few points clear about the right to a fair trial. This is still quite a novel procedure, and you can see that even though we are into the thousands on the numbers, it's still certainly quite a novel enterprise in the Crown Court, and to a certain extent that is why the sort of evaluation will be so critical of this. But from what we have seen so far, the pre-recorded cross-examination we think does not interfere with the defendant's right to a fair trial, although of course we want the evaluation to look at that sort of thing. The witness evidence will still be subject to the proper cross-examination, re-examination. It just happens far sooner, and following full disclosure, and of course by video. And both the defence and prosecution lawyers will be present in the courtroom during the pre-recording, as will the judge and the defendant. But clearly it's done in a managed way. In terms of the trial itself, the Section 28, I should probably say, the hearing is considered the first day of the trial, and essentially it's pretty straightforward, really. The evidence is recorded, and the video recorded evidence in chief. They are both played in the trial in the front of the jury and all parties, which means the witness itself does not have to be there on the day. I mentioned a case study, and this is a nice case study from a recent case in Newcastle Crown Court. This can be found, I think, on the Newcastle Chronicle, but some quotes on how a 21-year-old woman who acts as a special measure at Newcastle Crown Court. I'm talking here to allow you to sort of read what we've said on there. I'd certainly recommend going to the Newcastle Chronicle and seeing that. And also there was a very, I found a very helpful for those of you who listen to Law in Action, Joshua Rosenberg's Law in Action. He once did a very extensive piece on Section 28 and the use of Section 28, which I think goes some way to demystifying the process and shows how it's used in, well, I think in his instance, Kingston Crown Court, but how it's used in a number of Crown Courts. I hope everyone has had the time to read that testimony, which I won't read out. So that brings me to the end of my presentation, a question and answer session. Now, as you can probably tell, that was a very basic, but I hope helpful and illuminating overview of Section 28, and in particular what we've done with vulnerable witnesses and what we intend to do with intimidated witnesses over the years ahead. I am going to pause there and open it to any questions. Thank you.
Good morning, everyone, and thank you, Daniel, for a fascinating presentation. I'm Dr. Ryan Wilkinson. I'm a senior data analyst working in the Strategy and Change Directorate here in HMCTS, and I'm facilitating the Q&A for this session. And if you have any questions at all, please feel free to ask them by clicking on the question mark icon in the top right-hand corner of the screen. Daniel, our first question relates to the pilot that you mentioned and the locations of that pilot. So you mentioned that the Intimidated Witnesses pilot is running in 7 Crown Courts. Can you explain the rationale for choosing these locations and how long will the pilot last?
The pilots will last as long as it takes to fully evaluate the measures for intimidated witnesses. So, they've now been formally commenced by legislation, and they will continue to run in perpetuity or until any evaluation suggests otherwise. So, we're expecting them to run for some time, really. Why were they chosen? Why were the 4 Crown Courts chosen? Wood Green, Harrow, Isleworth and Durham? A number of factors, really. In order to successfully undertake these pilots, you need a Crown Court with sufficient capacity. And I think it's fair to say, and I think, well, I'm sort of stating the obvious here. Section 28, whilst it's great for witnesses and complainants in terms of allowing them to produce the best evidence available and to reduce the distress felt by participating in a criminal trial, it does have a quite a significant resource overhead. And, again, I'm sort of stating the obvious here, because not only do you have to record the evidence, but then you then have to play back the evidence, in contrast to a conventional criminal trial where witness or complainant is present and is just cross-examined in open court as part of that trial. There's also other elements that required in support of a Section 28 hearing. That's something called a ground rules hearing, where the judge and the parties will come together to discuss the format and the content of some of the questions. Now, that is part and parcel when the witness is vulnerable, but it's used sometimes also when the witness is intimidated. So that's essentially an additional hearing as well. So what I'm illustrating is that there is, additional resource required, additional input required from all parties. And to a certain extent, the pilot courts were chosen on the basis that they were courts that had the ability to accommodate that additional requirement, that had sufficient numbers of police trained CPS and police officers, where the Crown Courts had sufficient capacity and a degree of willingness, of course, to undertake the pilot. And so, that's how they were selected. There's no specific characteristics other than a willingness and a readiness and an ability to host the pilot.
Fantastic, thank you. Just had a question in that says, what safeguards are in place to ensure that witnesses do not falsely claim they are intimidated? Will the court be requiring some evidence, for example, from a police officer?
In some way, the sort of safeguards are, well, to a certain extent, specified in legislation. I think Section 17(4) and Section 62 of the Domestic Abuse Act are quite clear as to which offences are eligible, whether it's sexual or modern slavery or those involving a domestic abuse element. In some ways, a safeguard will come from the police and the CPS, who will identify and assess that eligibility from the start. So I think in response to that, I think I'm saying there's already quite clear and well-defined criteria, but that check will come from the police and the CPS before it's put to the court as to whether it should be suitable for a Section 28 pre-recorded hearing.
That is reassuring, thank you. Someone's asked, as someone on the autistic spectrum, would this be used for those on the autistic spectrum who are witnesses in criminal proceedings?
I'm not aware of any autistic witness giving evidence in this way, but if it did, it would fall into the vulnerable category, section 16 vulnerable category, whereby pre-recorded evidence was available for those under 18 and those with learning difficulties or some other factor that would allow their evidence to be improved if they gave evidence via the pre-recorded section 28 method. So I'm not aware of an autistic witness using section 28, but if they did, it would be through those vulnerable provisions.
I understand. Thank you. Somebody has asked, as I understand it, judges think that giving evidence is less effective via video link. Is there any evidence to support this, and will this belief impact on the rollout of the section 28?
I think I would point to the evaluation as the extensive evaluation that the Ministry of Justice will undertake as a way to answer those sorts of questions. You know, as I said in my presentation, you know, we're all still learning about section 28 and how it's being used and what the whether it has a bearing on the outcome of the trial, whether it has a bearing on whether someone pleads guilty or so on. And I think the evaluation will go some way to answering this using a proper controlled sample and a statistically significant number of cases in which to assess this against. So I'm slightly loath to give my personal opinion here and to point the questioner to what I hope will be an extensive evaluation concluded in the next few years.
Thank you. Maybe related to that point, actually, would it be possible for you to say a little more about the kind of the research being done within HMCTS or MOJ, and what exactly is being looked at, perhaps in terms of the evaluation and metrics for success, and over what time, what is being and kind of related to that, I guess, what's being done on behalf of kind of defence interests?
Yeah, well, I don't want to go too much into the evaluation because the terms have not been signed off just yet. But let me give you an example of what government statistical research evaluations usually entail, and could entail for this sort of thing. It will look at areas such as, I mentioned the additional time taken for section 28 hearings. How much time is that? What is the definitive additional resource requirement on all elements: judges, prosecution, defence counsel, police, CPS, and so on. I mentioned that it's very likely to look at things like plea rates, whether those who use section 28 are more likely to, those cases where there is a section 28 hearing, the defendant is more likely to plead guilty at some stage. It will look at outcomes, acquittals, I imagine, and it will usually, and again, this is what is normally undertaken for these evaluations, these government statistical research evaluations, it will normally look at a set of quantitative and qualitative data. So the qualitative data will be, of course, looking at the data from cases themselves, and I mentioned the sort of statistically significant number of sort of 300 cases to look at things like plea rates and outcomes and so on, and that will be supported by a quantitative assessment, and I imagine that will entail interviews with users for those who've made recordings, prosecution, defence counsel, police, CPS, judges, and so on, and that will all come together into what I hope will be a comprehensive evaluation.
Brilliant. Next question for you is maybe a slightly quicker one. On average, how far in advance of the trial does the pre-recorded cross-examination take place?
It's not a quick one, I'm afraid.
Okay.
It's usually some months before the trial, I think, is what I can say. It's quite difficult to put a definitive figure on it. So I'm sure listeners will know that the Crown Court is currently facing record levels of outstanding cases, and because of that pandemic-induced growth in caseload in certain parts of the country, there are quite significant waits for trials to commence at this stage. So I wouldn't want to give a definitive figure, but normally it's some months before the trial takes place.
Cool. Thank you. Someone wants to know, is there any interest in expanding what's being done here within Section 28 in the crime jurisdiction to other parts of the justice system, for example, family law?
Not that I'm aware of, no. We have considered it elsewhere, and in particular, one area under consideration is the youth court for this special measure, but nothing's been decided or agreed just yet. But I haven't heard of this being proposed outside of the criminal jurisdiction, and to a certain extent the nature of the recording and the process itself, perhaps when I think about it, perhaps wouldn't necessarily support public or private family law hearings. But I've not heard any suggestion that it will be broadened out beyond the criminal jurisdictions.
I understand. Thank you. Our next question says, what are the rules, or I guess what is the general situation if the defendant doesn't agree to submit pre-recorded cross-examination before trials?
Well, it's not necessarily it's not the defendant who would submit the evidence. I think the defendant's role in this, if this is the question, the defendant will have the opportunity to make an application for the witness or the complainant to give evidence in a different, to make an application essentially against a special measure, but the defendant won't necessarily have a role in the content of the recording other than what has been agreed by prosecution and defence counsel, things like the ground rules hearing and so on. Is that I'm not, I think I'm probably saying I don't quite understand the question, Ryan, but have another go at asking it. I'll see if I can give a better answer.
Apologies. Yes, it probably links to another question that we've got, which says, what assistance, if any, is available to a vulnerable defendant? We've obviously been talking witnesses, vulnerable victims, but is there any kind of provision for defendants who would be categorised as vulnerable?
In terms of not during Section 28, not through the sort of Section 28 provisions, and perhaps this is one thing that the evaluation may look at, or further developments of Section 28, whether this is something that should be suitable for defendants. But no, there's no sort of specific measures other than the support from their counsel and solicitor that is provided to defendants in these trials.
Cool. Thank you. Our next question says, who has the final say as to whether Section 28 can be used? Can it be overruled or challenged?
It's the trial judge who has the final say.
That was a nice simple one. And I guess then the next one would be, are there any plans to expand the use of Section 28 to all Crown courts in time, obviously pending the results of any evaluation from the pilot?
Well, it's certainly something under consideration. How can I put this? You don't necessarily undertake a pilot without having a view on the future, and I think ministers will be keen to try to roll this out elsewhere at a suitable moment. I've mentioned the evaluation. Yeah, I think there is a desire to roll out further, but there'll also be a need to evaluate the process as well to ensure that we can deliver it in the most suitable and effective way.
Yeah, that makes sense. Cool. We have another question that's just come in saying, it's often the attending police officer who may describe to the victim at the time of taking a statement the possibility of special measures at court. will that be the same first description of explaining pre-recorded cross-examination, i.e. who explains it all first?
Yes, normally the first encounter they will have with the prospect of pre-recording their evidence is via the police. They will, so to a certain extent, this is why police support and police training in particular is so critical to the success of this. Where we have seen large numbers of users using this special measure, it's normally where that there has been extensive training, awareness, and management across the police force area. But to a certain extent, it's the first contact will be via the police, but it really is a cross criminal justice system enterprise, brought together by both the police and the CPS, Defence Council and HMCTS, all parts of the system, as with so much in the criminal justice system, need to come together to make the thing effective.
Yeah, thank you. Just trying to scan through the remaining questions if there are any. We have maybe one more question that we'll get to, which is, how is Section 28 applicable under Youth Justice and Criminal Act? How does the law value or assessed, or how is the law valued or assessed under the Youth Justice under Criminal Act? Sorry, whoever's asked that question, I'm not quite understanding it myself. So if you want to resubmit your question, then I'm sure that we can get Daniel to answer it. But yeah, I guess actually there's not actually that many more questions left, Daniel. So what time are we? Quarter past. Yeah, I think what it might be safer to do then in the meantime is to say thank you again for a very good presentation and for answering the questions so diligently. And if anybody has any further questions that they might have for Daniel, then please submit them here, and then we can ensure that we can provide a thematic response to any questions that will be published online on gov.uk after the public user engagement event. But with that, I'll pass back over to Daniel in order to close.
Thank you, Ryan. Yeah, just to finish by saying thank you very much for participating this morning. Thank you very much for listening, and to sort of echo Ryan's point, if there are further questions, please do get in touch. I'd just like to say a final thank you to those who have organised this, in particular David Wilson, and to also ask that you tune in tomorrow to the final public user event question and answer panel. I think it's at 3:45 tomorrow, where the panel, of course, will be answering questions on all manner of topics, whether criminal, civil, family, and so on. But thank you very much for listening. Thank you for your time and your ears, and say farewell. Thank you. Goodbye.